Welcome back. How productive was your coffee break? What did you find out about what answers can be found in the Swiss Code of Private International Law for our case? Let's go through the conflict of laws issues one by one. The first issue is jurisdiction. In order to find the provisions on jurisdiction that could apply, we have first to go into the specific part of the Swiss Code of Private International Law, namely into Chapter 9, Section 1 on contracts. So here we are, Chapter 9, Section 1. It starts with Article 112, entitled Jurisdiction General Rule. According to this article, the Swiss courts at the defendant's domicile, or in the absence of domicile, those at the place of habitual residence of the defendant, shall have jurisdiction over actions arising from contracts. So this is the general rule. The defendant's domicile determines jurisdiction. But does it help in our case? Who is the defendant in our case? Well, since XSA wants to sue Y Limited, XSA is the plaintiff, not the defendant. So Article 112 is not helpful in our case in order to establish the jurisdiction of a Swiss court in Yverdon. Let's move further to the next article, Article 113. According to this article, there can also be jurisdiction of the Swiss court at the place of performance. Article 113 states that if the characteristic obligation of the contract is to be performed in Switzerland, an action may also be brought before the Swiss court at the place where the obligation is to be performed. The starting point is the characteristic obligation. In our case, the characteristic obligation appears to be the obligation of XSA to deliver a machine to Y Limited. But what about the place of performance for that obligation? We can assume that the machine has to be built in Yverdon in Switzerland, but it has to be delivered to Y Limited based in India. So it's highly questionable where that place of performance really is in that case. And there is little chance that a Swiss court in Yverdon would admit its jurisdiction on that basis. Apparently, there isn't a sufficient basis in the specific part for establishing jurisdiction of Swiss courts in the present case. But let's check the general part. Let's check whether we can find any provisions in the general part that could change something about that outcome. In the general part, we find Article 5 entitled Choice of Court. According to Article 5, Paragraph 1, first sentence, the parties may agree on a court for an existing or a future dispute concerning pecuniary claims arising from a specified legal relationship. So there is always that option of a choice of court by the parties. This can be done in the original contract in the form of a choice of court clause. But even if there is no choice of court clause in the original contract, the parties still have the option of agreeing on a court later on for an existing dispute, for a dispute that has already arisen. And this remains an option, of course, in the present case, since it is about pecuniary claims. There is even more. Article 6 provides for a specific form of a choice of court implicitly made by the parties during the proceedings. According to Article 6, in the case of pecuniary claims, the court before which the action is brought shall have jurisdiction if the defendant proceeds to the merits without contesting the court's jurisdiction. This is amazing. This kind of implicit choice of court is enough already to establish the court's jurisdiction. So as soon as the defendant fails to contest the court's jurisdiction while proceeding to the merit of the case, the jurisdiction of the court is established. Let's assume that the court in Yverdon admits its jurisdiction on those grounds. In that case, of course, the court would refer to Swiss law as the lex fori as far as procedure is concerned, and also with regard to the private international law rules determining the applicable law. So again, we have to go into the Swiss Code of Private International Law, and also in that respect, we have to start by having a look at the specific part, namely Chapter 9, Section 1 on International Contract Law. And here we can find Article 116 that opens the series of articles referring to the applicable law. According to Article 116, paragraph 1, the contract shall be governed by the law chosen by the parties. And paragraph 3 adds, the choice of law may be made or modified at any time. If made or modified following the conclusion of the contract, it shall be retroactive to the time the contract was concluded. So as you can see, the parties are always free to make their own choice of law. And this can be done in the original contract by including a so-called choice of law clause. But it can also be done later on in a separate agreement on the applicable law. But let's assume that in the present case, we do not have any choice of law made by the parties. That brings us to Article 117 that applies when there is absence of choice of law. Article 117, paragraph 1 states the principle that in the absence of a choice of law, the contract shall be governed by the law of the state with which it is most closely connected. Paragraph 2 offers a definition of that closest connection, stating that it is presumed that the closest connection exists with the state in which the party who must perform the characteristic obligation is habitually resident, or if the contract was concluded in the exercise of a professional or commercial activity where such party has his place of business. And paragraph 3 illustrates that definition by providing a series of examples. In particular, the following shall be considered the characteristic obligation. A. The obligation of the alienator in contracts of alienation. B. The obligation of the party transferring the use of a thing or a right in the case of contracts concerning the use of a thing or a right. C. The service provided in the case of mandates, work and labour contracts and similar service contracts. D. The obligation of the custodian in custodial contracts. E. The obligation of the guarantor of surety in guarantee or surety contracts. So what does this mean for our case? Considering those examples in Article 117, paragraph 3, what we can see is that it is always the party who must perform something specific that has the characteristic obligation. It's never the party that has just to pay an amount of money. Applying this to our case, we can see that XSA has to perform the characteristic obligation by delivering that machine, while Y Limited has just to pay an amount of money, $5 million, which cannot be the characteristic obligation. So the conclusion that we reach on the basis of Article 117 is that Swiss law is the applicable law. Let's assume in the next step that the Swiss court in Yverdon renders a judgment in the light of Swiss substantive law that is in favor of XSA. So XSA wins the case in front of the court in Yverdon. It succeeds in obtaining a judgment in its favor. But this isn't the end of the story. There are other challenges ahead, namely recognition and enforcement. XSA would have to enforce the judgment it obtained from the court in Yverdon against Y Limited that is based in Jaipur, India. This poses the challenge of enforcing a Swiss judgment in India. Now, the conditions under which a Swiss judgment can be recognized and enforced in India are not a question of Swiss private international law, of course. Rather, this is a question of Indian private international law. And I can tell you that according to Indian private international law rules, there is no way to enforce foreign judgments such as judgments rendered by a court in Switzerland. So the situation that XSA faces here is that it went through a litigation that maybe has taken some years or at least months, that has involved a considerable amount of cost, and that judgment that was obtained in that litigation proves to be completely useless in the end because there is no way to enforce it in India. That shows you that all of those private international law issues have to be anticipated. This has to be checked beforehand. Before engaging in a litigation in Yverdon, you have to make sure that the judgment you obtain in a best case scenario will be enforceable at the place where you would have to enforce it. Otherwise, you just lose time and money. So this makes private international law issues quite challenging. You have to anticipate all the different questions in all three stages, and you have to check that before. In the next stage, I would like to submit to you a slightly different situation. At first glance, it looks pretty much the same. But taking a closer look, you can see that the facts are slightly different. It's just the other way around. This time, it's Y Limited, based in Jaipur, India, that is to deliver a machine to XSA, based in Yverdon, Switzerland. And XSA has the obligation of paying the price of $5 million. So what about this case? Let's assume that Y Limited wants to sue XSA in Yverdon because XSA refuses to pay the amount of $5 million, saying that that machine doesn't function properly, which according to Y Limited is not true. So in such a situation, is the court in Yverdon competent? And what would be the applicable law? This sounds like a perfect task for your next break. And in order to keep your coffee intake within reasonable proportions, I would like to suggest that you opt for orange juice, for example, or whatever you like.